Okay, thank you very much, and thanks the organizers. Okay, this is a bit problematic. So first the technicalities. Is this better? Any better? Okay. I'm fine. Okay. So for the cameras, I'm sorry, I'll be just walking around, so I hope you could follow me. Is it okay? Thank you very much, I'm used to it. So this goes for my background, and that's the first thing when you're talking to a lawyer. Of course, this is not legal advice. Disclaimer, we can discuss it then. And if it would be legal advice, there will be a bill coming after that. So this is not a legal advice. This is, so to say, the musings of a copyright scholar. Really light after lunch session. I don't know whether this was a good idea from the organizers to put a lawyer just after the lunch, but I'll try hard. I'll just the pictures at least will be moving. That's the only thing I can promise you. As regards to my background, I'm a copyright lecturer in copyright and intellectual property rights at our university. I work both also as a lawyer for the technology transfer office, and I also work as the legal lead for Creative Commons for the Czech Republic. Also have to set myself a timer, sorry for that, now. See, the pictures are moving. What I would like to talk about, well, you can see that, of course, the Prezi is online available at tiny.cc/plagiarism15, and also feel free to give me some questions via Twitter. I'll try to follow. So, the Prezi is there for you. What I would like to talk about now in this short presentation is I would like to have a quick look of what's the problem and why the lawyers have started now to deal with these issues, because not only other academics that are interested in academic integrity do deal with it. Then I will have a quick look on this very famous dichotomy that everybody of you is, of course, very well aware of, and that is that plagiarism does not always constitute copyright infringement, and copyright infringement does not always constitute plagiarism. And then I will part and leave you with some ideas, with some food for thought, and especially some update on how are we doing in the Czech Republic as regards to legal punishment, and punishment will be discussed in this lecture in the Czech Republic. So the first thing is, and of course I have to lean on the authorities. Probably you know Judge Posner with his famous cat Pixie, and that's a judge from the Court of Appeals of Chicago, and he wrote this little nice book, The Little Book of Plagiarism, that of course I suppose that you know. If not, it has around 150 pages, and I do recommend it. That's a very nice view how lawyers see this, issue. And now he's talking about why are we even dealing with this plagiarism now? I don't want to be a Captain Obvious for you, because yeah, why do we talking about this topic here? We have a conference, biennial, etc., etc. And the thing is, there is a structural and a different shift in how do we perceive the plagiarism now. The problem is that because of this development of technology, the plagiarism is so easy, and especially is so easily detected. I don't want to be, again, the Captain Obvious here, how the plagiarism is detected. It's all fine, there were many excellent lectures on this issue. However, we have to perceive it in the shift and in the running of time. I don't know whether you are aware or not about the affair that was happening in Germany in 2014, when Annette Schavan, who was a Ministry of Education, and it's extremely problematic, and she was accused of plagiarism, of course. And her doctor father, so the doctoral advisor, said that, well, you don't have to, and you cannot apply the limits we have now to the works that have been submitted in 1980s. As you can see, the work, it is in German, so no translation, the work was completely with all the academic standards. The problem was she plagiarized 50 pages, so in the 80s, maybe, probably. So we cannot measure it with today's, all of these tools we got to analyze and find out who was plagiarizing. So this is a very interesting point that we should take in mind. And the problem is why the lawyers are now dealing with the plagiarism, and plagiarism is such a topic in general, is that the democratization of creativity. Before the development of ICT and intermediated communication. Not all that was written was published, and not that was published was consumed, and not that all that was consumed was reused. And the problem nowadays is that the plagiarism is so technically easy. And of course, you all know that the copyright here is to protect the expressions, the words as they have been written, not the ideas behind them. But nowadays, and that's what we are now facing, and I'm facing it especially, sorry I don't have any hard data on this, but there were a lot of presentations that bring up the same conclusion. The building blocks now of the text are very easily used as the building blocks of creativity. A really very nice example, and this is a real example. I've stumbled upon this exam period as I was teaching a course on information law and information law and technology, and the students had to write a simple assignment. It was really 2 pages long, and they have to discuss the pros and cons of Creative Commons licenses and the public licenses in general. He submitted a really nice test. Of course, you don't have to read it, but this is just like, this is the amount of the text, And we found it a wee bit problematic that we have read it somewhere, of course. Then we performed, with the help of our own system, we got we call it very nicely 2-piece in a pod system. So there's a similarities in egg. And then we performed the analysis, and we asked the student, could you please give us the citations, the quotations? And he said, oh, I used these articles. And he didn't somehow indicate how he had used this text. And then we run it for himself. And as you can see, this in italics, it's always a citation from where the text was literally copied. And as you can see, we had to use a lot of colors, and the student was very creative because he put his own creativity here. Non-compatibility, and that was it. So the result was, yeah, dear kind sir, this assignment is not compatible, both with copyright law as well as the academic ethic. And the problem is, right about now, why is the plagiarism so fascinating? Why are you even here? And that's also what Mr. Posner said. The fascinations are and that's what I want to especially focus on, the historical and cultural relativity. I don't know, I have seen quite a lot of presentations here, both online and offline. I've read the papers, and I got the feeling the ambiguity is the word. We have to, and this is again Captain Obvious to the rescue, and he strikes again. Do we even know what the ambiguity and what the plagiarism is? But there's a problem when the law comes and the punishment comes. You cannot retroactively punish people for what they do not know whether they have committed or not. And so that's what that was ringing, the bell was ringing bell here quite a lot in these lectures. We have to raise awareness. We have to spread the word. The question is, what do we have to spread the word about? And the thing is, the motives and excuse were also discussed in this. And about the punishment and absolution, the question is, and that's the problem with plagiarism, to accuse somebody of plagiarism is very easily. To get rid of the plagiaristic stain is very, very, very complicated. And it's very easy to throw mud and dirt at somebody, but how to run then the clean slate? The problem is that actually when you are punishing plagiarism and you don't have rules set ex ante, then you have to punish him based upon ex post opinions of experts. The question is this okay or is this not okay? And the problem is with the democratization of culture and culture production, we have come to this clash of discourses. And of course, I know, I'm quite sure that you are well aware of this, so to say, open content movement, of this movement that shares the idea, and this is especially very prominent in the area of art, and it's being propagated by free culture movements, also by free and open source software movements. The thing is that we should live in a shared culture, and a lot of doctorates, I would say, a lot of theses were issued and written about this topic, including mine, that we live in a shared culture. And the students, and not only the students, but also the academics, live in this environment where there is actually no originality and there is no original creativity, because creativity is only, and that's what late Steve Jobs said, creativity is just only about connecting things. And basically, the creativity consists of copying, consists of transformation, and of combination. And the problem is, again, this is even getting into political discourse. If you look into the programs of political parties, mainly in the pirate area, so to say, they do really tend to, so to say, institute that there is no such thing as originality. Even in my abstract, I have used this famous quote from Mr. Trent Reznor, who stated in the excellent song copy of that everything is just exactly a copy of a copy of a copy, and that everything has been said before. And the problem again is, it's even get, so to say, rationalized. And it even gets witty. The state of discourse is, plagiarism, it's, you know, this little old joke, everybody knows that. I do recommend you, if you look at the Prezi, this quote is usually should be authored by Wilson Mitzner, but it goes well to the 11th century, therefore it's not original itself, but never mind, again, plagiarism. But the thing is, really, a primitive example. Copy one source, it's plagiarism. Copy two, it's called academic research and academic integrity. On the other hand, we are living in the world where the originality is trying to be, so to say, perceived as the biggest, so to say, and the noblest thing that an academic can ever achieve. And the plagiarism is basically the end of you. And now we have to, so to say, reconciliate both of these discourses. And the problem is, a lot of people do tend to forget that the creativity that's being combinatoric always relies on naming of the sources. Again, Captain Obvious. We will have a look at it later in the course of the lecture, or in the course of this talk, as we will approach now the issues of ethics and law. Of course, the intertwining between law and plagiarism and ethics is very simple. Let me give you a brief idea how a copyright work, how the copyright law works in a nutshell. I know all of you, of course, know that, but let me remind you what is protected by copyright and how does this exactly work. I have to try to put it in, squeeze it in 2 minutes. If you don't understand anything, don't be ashamed. Our students don't get it even after 12 lectures and courses. So, you got an idea. This idea is then expressed in a creative manner that could be perceived, could be objectively perceived. In the Anglo-American tradition, you have to fix it on a tangible medium. In the European, it can be even ephemer, which means that could be only, so to say, pronounced or sung. Then you got the protection, and then that, based on the Berne Convention, is on the so to say, the principle of territoriality, then granted all over the world. And if you want to use both the whole work or part of it, you have to either wait until the author is safely dead, which is usually 70 years, in the Berne Convention is 50 years after his death, or you can be very courageous, and it's one of the talks with academic integrity, it takes courage. Using copyright exemptions, it also takes courage. And the last thing is that you can have the consent of the author. And that's it. If you don't have this, if you are not in these 3 areas, so to say, then you're done, you're busted, and your use of the work is infringement of copyright. Again, the idea expression of dichotomy strikes back. It has been already declared in the agreement on the trade-related aspects of intellectual property right that the copyright protection does not extend to mere ideas. It always protects the protection. In the Czech Copyright Act 121/2000 is the same thing. The idea, the procedure, the principle, the method, discovery, scientific theory, statistical diagram, or similar item as such is not protected by copyright. The problem is this official or unofficial translation that is available at the Ministry of Culture uses the statistical diagram in a way. In the Czech Republic, it's a statistical graph. So if our Czech researchers read this exact statement, they say, okay, it's okay, I will just go to any nature science journal, I will just simply copy the graphs because it is not protected. So this is a wee bit problematic, but still you get the idea. The idea is not protected, so the only thing that's protected is actually, by copyright, is the copy pasta. That is the Ctrl-C and the Ctrl-V. And only the copy pasta is made to ruin every bit last of originality. And, however, you could also say, fine, I will use the work, and I will use it only on the basis of a copyright exception or exemption. The thing is, do you really want to do that? And the question is, this is law. This strictly defines, or should strictly define, that it protects only the expression, and it has nothing to do with the academic code of conduct, academic ethics, etc., etc. The problem is, in our Copyright Act, and usually in the acts of European other member states of the European Union, there is always this condition that you can use the excerpts from a work or small works, just a part of it, not the whole work, but you have to quote the source, quote the author, and of course name the author and where did you get the work from. However, there is this nice little stretchy legal term. It must be to the extent complying with fair practices and required by the specific purpose. So through these, so to say, rubbery terms, you could actually squeeze in the academic ethics. Therefore, it would be quite wrong to say that the academics and the rules of conduct do not have any, so to say, influence on how do we perceive copyright infringement of the works as such. The thing is, now we were on the law side. Now let us focus on the ethics, and this definition is taken from the European Research Code of Conduct, which is not properly stated here, which is quite a problem, but it will be corrected lately for the cameras. No copyright infringement intended, you know. These are the excuses and we're using. The question is, and the unbearable vagueness of plagiarism. I don't want to really go deeper into this typology of plagiarism because that would be again the work for Captain Obvious for this whole 2 days we've been discussing this issue. But the question is, for example, the structural plagiarism or safe plagiarism do not have anything to do with the law. However, one of the typology that has been used by Weber Wolf in her excellent book False Feathers. These other types, for example, translation, or when it's disguised, or the cut and slide means that you cut up the text and you put the text into footnotes. And these all are regarded as copyright infringement if you use the whole text. This is really fantastic. How do we deal with what's enough, what's not enough? You don't usually get, so to say, quantification in the sense of that 7 words will be okay, 11 words are not okay. However, the Court of Justice of the European Union, so to say the utmost legal court and institution that's responsible for explanation and interpretation of European law, said, in the case Infopak, that even 11 words could be protected by copyright if they constitute a copyrighted work in themselves. So we would have a tautology, but 11 words are okay. In Czech Republic, we are even better. Our Supreme Court said that even 3 words could be protected by copyright. Okay, and of course, we have this other type of academic misconduct that we've been addressing in excellent lectures about ghostwriting and contract cheating and honorary authorship that I will address later. Here the problem is that you don't use the work as such, directly, but not the economic rights itself, not the economic right to reproduction is infringed, but the moral rights. I think that the Americans do not know. They have the moral rights only to visual works of art, not to texts. We here in the Europe do stand ground on these principles that even the moral rights are protected. And in this case, if you, so to say, claim the authorship that's not yours, then you are not only infringing the economic rights if you're using the text itself, but you could be also infringing the rights of the author. And the thing is now about punishment, and how do these punishments intertwine? First, of course, is the academic integrity. I would say this is the problem, and that, so to say, your good name, the name is the only thing you got as an academic researcher, is simply gone. I don't know whether you have followed the case of the German Ministry of Education, but it was very well popularized, and the result was that there was even a demonstration that was demonstrating for her retreat from the position, and she was being dragged around as this nice statue, Plagiarism Chavan. So this is like the Vox Populi turning against the plagiator. This did not happen in Czech Republic at all. We have the approach, just snug it under the rug, sweep it under the rug. But in Germany, as you can see, this is the thing that goes above the law, or say next to the law. As regards to the law itself, in Czech Republic, the punishment, as it goes, disciplinary misdemeanor, you can be warned, and this was addressed in the excellent presentation at the workshop before. You could be also expelled, or so to say, excommunicated from the school. However, we don't have a ban on enrollment in Czech Republic yet, which means that if you are expelled from the school, you can enroll again. The funny thing is, as regards to the academics, here you are not on the ground of the Education Institution Act, which means there is no relationship as a university and student. The issue we are now dealing with is the contract of employment, and you can be instantly dismissed if you have an intention to grossly and aggravatedly, so to say, breach the ethical codex that is being a part of your labor of contract in the Czech Republic. If you have a look at the copyright infringement issue, the first thing we have to bear in mind is that you can again pursue the punishment on two levels. On the private law, the respective authors of whose rights have been infringed have to act in a work in a way that is, so to say, that is planned by the Czech Copyright Act. You can simply file a private law claim claiming that your authorship rights, moral rights have been infringed, even the right to the integrity of the work if he uses it not correctly. And of course, you can claim for satisfaction, which means that an apology has to be issued, and of course you can claim for damages and just enrichment. This is more interesting, so to say. We can go in a way of academic criminality. If it reaches a certain level of, so to say, of aggravateness, you can be even pursued on the criminal law level. And the problem is, however, we are again running into circles, because in the Czech Penal Code, it is not exactly stated what is being a crime against copyright. It is stated if the copyright is infringed and it reaches certain level, substantially, then whoever interferes is liable. How do you find out whether he has interfered or not? You have to look at the act of copyright. As regards to ghostwriters, we're just discussing it with Mr. Newton. In the Czech Republic, even, and that's a bold claim, I know, this is not a legal advice, nobody should pursue it, but this is a bold claim in my opinion, that even the ghostwriting companies could be pursued or could be, so to say, criminally prosecuted as an accessory to the crime of copyright infringement. And if this ghostwriter is a natural person, he can also be an accessory, accomplice to the crime of infringement of other rights. This is a really interesting crime that says that whoever causes the serious harm to rights of someone else, that could be also the university, by bringing another person into error, could be punished. Therefore, that if you are pretending that you have done this and you want to gain a gain, sorry for that, in the form of academic degree, you have brought them into error and therefore you are criminally liable. Another thing is, and that's not my issue, not my idea, that's the idea of Professor Telec, who is quoted here, is that even the institution itself, if it's not doing any right, and if the institution is, so to say, not proactively defending itself against plagiarism, or even if it's using plagiarist result, for example, to attain grants and money to get a public subvention, it could run into the unfair competition rules, because she's on the market with other universities, they are competing for public money, they are presenting themselves with results, with publications, but if these publications are falsified, if these are not, so to say, academically correct, they are using unfair means of competition. So this could be also a direction where to think. And now let's part in the last 8 minutes of my presentation with the food of thought. As regards to prevention, of course, education has been stated quite a lot of here. A lot of excellent research is being done. How do the students see and perceive plagiarism? The question is, can we use more open access for avoiding plagiarism? In this case, we could, if you have an open access article that is licensed under the Creative Commons licenses, could help you to round out of the private law liability. There is the civil liability for copyright infringement, because you have the consent. The author is not dead, you are not running into the exceptions area, but you have the consent that is granted you by the Creative Commons license. However, the problem is, even these licenses do need attribution, but this is usually overlooked. You go to Wikipedia, it says, nobody's in there, there is a nice picture, I've just taken it from the internet, no need to attribute. Again, this is a violation of the copyright terms of the Creative Commons licenses. If you have violated the terms, you don't have any legal title to use the work, and you can then rely on the 2 second options, that is the exception, and that is the death of the author. So this could be, however, avoided with a technical standardization. You can have a closer look in the presentation. There are already tools developed how to make the attribution via Creative Commons licensing easier. Even on the web page of Creative Commons, if you choose the proper license, you can usually use and easily use this proper attribution that suffices both the terms of copyright the terms of Creative Commons, as well as the quotation. That's another thing. So to say, the problems that even the Creative Commons licenses do not solve the problem of lazy citation. And of course, then that's the topic I've been discussing in the beginning of the lecture. A lot of people think, okay, so it's on the Creative Commons, I can do whatever I want to do with them. And that's again the problem. You have the copyright is okay, it's been cleared, but still you have to follow the academic rules again. As regards to detection, how to find out, in this case, I'm sorry, I wouldn't discuss on this because there are a lot of excellent speakers who have already done this. And now I will just focus on the punishment. The problem is, and that's been stated here many times, if you do not know what the plagiarism is, how you want to punish it. And the problem is, these are exact quotes that are in the European Code of Conduct for Research Integrity. And this should be a code of conduct. So you should look into it and say, okay, so I should know what I should not do and what I should do. And the question is, well, the demarcation line is very blurred line if you're following the development of case law in America. So this, this is also a case of the blurred lines song, a very nice issue of plagiarism again. And it's unacceptable, and still acceptable behavior is not always clear and beyond academic debate. Okay, so who should debate it if not the academics themselves? And the question is, do we know where the boundary between plagiarism and careless citation is? That's one of the questions. Hey, I want to know that. That's because I have looked into the European Code of Conduct. Never mind. The thing is, that is now being discussed very heavily, and I think that's the big topic, is, from last week, my professor demands to be listed as an author on many of my papers. That is, the honorary authorship. I've researched into this topic because we have run it on the, in the university, into this issue. And now the only thing I found is the Vancouver Protocol that says how to credit an author in order what has the respective authors done on it. So there isn't even a Ph.D. comics on this topic, that first goes the head of the institute, second goes the one who made the research possible via the grants, then goes the man who actually, or woman who actually wrote it, then goes the cleaning lady, the one who got the data. But the problem is, if you look into the both European Code of Conduct as well as in the law itself, the author is the natural person who created it. And the one who has only contributed or has given the impulse to create the work is not the author. Thus, these are also infringement of copyright and prima facie case of plagiarism. The question is, isn't this the issue of the vicious cycle, how to get out of this vicious cycle that you need more papers. If you got more papers, you got more career progress, and then you need more funding, and then it goes again and again, and you get more funding because you got more papers. The question is how to break it. That's why are we here, to debate it, the vicious cycle. And the last thing is I want to discuss and have a look at it is the degree revocation. In Czech Republic, there is no issue how to proceed if the university finds out that the thesis was plagiarized. There was this case of Pilsner law degrees. That means there were degrees that were issued very quickly. The joke was running that what you're doing on weekend, oh, I'm studying law in Pilsen, etc. And these were clear-cut copy-paste cases of plagiarism. However, the school found out that they don't have any means, legal procedures, how to strip the people of the title. And the question is, what's the legal actually? What's actually the legal nature of the title? The standard interpretation and so to say, explanation was that it's only a certification and graduation of the awarding of the academic title. It is not an administrative act in itself. However, it could be revoked, but only within 15 months of finishing of the studies. After that, you're in the clear, you are protected by good faith. As of now, and this is very topic, this is very up to date, in Prague, right now, an amendment is being discussed by the respective committee on higher education, amendment to the act that would get in a new paragraph, a new article that will give this right to strip and revoke the degree titles to the rector of the university if there is, however, if there is a really an intent, and clear intent to so to say, to break the law, to commit a crime or to commit an infringement. And if this is true, and if there is a judgment, or it is found out in any other reasonable way, the person could be stripped of her title, and this is within 3 years. And I know that the 3 years, the term is very, very, so to say, again, rubbery. It's first is when the studies are finished, 3 years after the studies, or if there is a judgment in force, then since the beginning of the force of this judgment. This means that if you find out 10 years after the degree has been awarded, you could initiate a lawsuit, or you can make a criminal procedure that there was copyright infringement. If it's okay, then you can initiate this administrative procedure. And with these words, I would like to part, as the time is running out, and I would like to thank you for your attention. And if you have any ideas, discussions, comments, etc., I welcome it on Twitter or in person. Thank you.